to the next lecture of American Government 2. I'm your host, Dr. Michael Baggs, and our topic this week is the Texas courts. The Texas court system is structured in a hierarchical manner, with different types of courts handling various categories of cases. Texas courts are divided into two categories: constitutional courts and statutory courts. Constitutional courts. Constitutional courts are established by the Texas Constitution and have jurisdiction over major legal matters. They include the Supreme Court, the Court of Criminal Appeals, the Courts of Appeal, the District Courts, the County Courts, and the Courts of Justices of the Peace. We will start at the top of the court system and work our way down. Texas Supreme Court. The Texas Supreme Court is the highest appellate court in the state of Texas for civil matters. It is an essential part of the state's judicial system, with significant authority over a variety of legal issues, and it has exclusive jurisdiction over civil cases in the state. This means that it is a court of last resort for all civil matters, including contract disputes, torts, which are personal injury and negligence cases, property disputes, family law cases such as divorce and child custody, and probate cases. As the highest court in the state for civil cases, the Texas Supreme Court has the final word on the interpretation of Texas law. Its decisions are binding on all lower courts in the state. The Texas Supreme Court consists of 9 justices, 1 Chief Justice, and 8 Associate Justices who all serve 6-year terms. They are elected in partisan elections, meaning candidates run as members of a political party, Democrat or Republican. Elections occur every even-numbered year, with approximately half of the justices up for election at any given time. After a term, a justice may run for re-election. There are also retention elections where voters decide whether or not to keep a justice in office after they were appointed by the governor to fill a vacancy. Justices can be removed from office only through impeachment or voluntary resignation. Salary for a justice on the Texas Supreme Court is $168,000 per year, plus $25,500 more for the Chief Justice. The Texas Supreme Court reviews cases that have been appealed from the lower appellate courts, such as the courts of appeal or directly from district courts in certain cases. However, the court has discretionary jurisdiction, meaning it can choose which cases to hear. It primarily hears cases by granting petitions for review. That is, the parties must file petitions to ask the court to review decisions made by lower appellate courts. It typically selects cases that involve significant legal issues, those where there is a split in interpretation between the lower courts, or cases that have broad public or legal implications. The Texas Supreme Court has the authority to establish rules of procedure for the Texas court system, including rules governing the practice of law, the conduct of judges, and the operations of the courts. The Texas Supreme Court also oversees the administration of the state's courts, including the discipline of judges and the regulation of legal profession. It works to ensure that the lower courts function efficiently and in accordance with the law. In certain cases, the Texas Supreme Court has original jurisdiction, meaning it can hear cases that have not been heard by any lower court. This is limited to cases such as barred disciplinary proceedings and certain types of mandamus actions. These are requests to compel a lower court or government official to act. The court can review the constitutionality of laws and government actions, ensuring that they conform to the Texas Constitution and the United States Constitution. Texas Court of Criminal Appeals. The Texas Court of Criminal Appeals is the highest court in Texas for criminal cases. It plays a critical role in the state's criminal justice system, handling appeals from lower courts, interpreting criminal law, and ensuring that criminal convictions are just and consistent with the law. The Texas Court of Criminal Appeals has exclusive jurisdiction over criminal cases in the state. This means it is a court of last resort for all criminal matters, including appeals of criminal convictions, that is, felony cases, capital punishment cases, etc., post conviction writs of habeas corpus, which are requests to challenge a conviction after the case is final, and death penalty cases. The court consists of 9 judges, one presiding judge, and 8 associate judges who also serve 6-year terms. They are elected in statewide partisan elections. 3 judges' terms expire every 2 years, and judges must, by law, retire at age 75. There are no term limits for the Court of Criminal Appeals, so a judge may serve multiple terms if they keep getting reelected. The court primarily hears appeals from individuals convicted of crimes in the lower courts, including both trial courts, district courts, county courts, and intermediate appellate courts, the courts of appeals. It reviews whether the law was correctly applied in those cases and ensures the defendant's rights were upheld during the trial. These post conviction challenges allow individuals to challenge their convictions after the case has been finalized. These can include claims of ineffective assistance of counsel, new evidence that may exonerate the defendant, or other constitutional violations that occurred during trial. One of the most important aspects of the Texas Court of Criminal Appeals is its role in reviewing death penalty cases. Texas requires all death penalty cases to be reviewed by this court. The court must determine whether the trial and sentencing were constitutionally sound and whether the death sentence should stand. In addition to appeals, the court has limited original jurisdiction. It can issue writs of mandamus, which are orders compelling lower courts or officials to perform a specific action, prohibition, and habeas corpus in criminal matters. The court exercises discretionary jurisdiction in deciding which cases to hear. It does not automatically hear all criminal appeals. When a party is dissatisfied with a decision from an intermediate appellate court, they can file a petition asking the Court of Criminal Appeals to review the case. The Court usually selects cases that present significant legal questions, involve new interpretations of the law, or address issues that are important for the criminal justice system. The decisions of the Texas Court of Criminal Appeals are binding on all other courts in the state. Its rulings set precedents in criminal law and procedure in Texas. The Court of Criminal Appeals has the final say on criminal law in Texas. Its rulings cannot be appealed to any other Texas court, and federal courts generally cannot overturn its decision unless there has been a violation of federal law or the United States Constitution. Courts of Appeal. Texas Courts of Appeals are intermediate appellate courts in the Texas judicial system. They have appellate jurisdiction, meaning they review cases that have already been tried in lower courts, ensuring that the law was applied correctly and that the proceedings were fair. They do not hold new trials or hear new evidence. The courts review cases from various lower courts, including district courts, county courts, justice of the peace courts, and municipal courts. The Texas Courts of Appeals have jurisdiction over both civil and criminal cases. There are 15 courts of appeal in Texas. The state is divided into 14 appellate districts, with each district having a court that hears appeals from lower courts within its region. The 15th Circuit Court of Appeals has statewide civil intermediate appellate jurisdiction and exclusive intermediate appellate jurisdiction over matters arising out of or related to a civil appeal brought by or against the state or a board, commission, department, office, or other agency in the executive branch of the state government. In addition, the 15th Circuit Court of Appeals has exclusive jurisdiction over appeals from the Texas Business Court, which has jurisdiction over cases involving business disputes valued at more than $10 million. Each Court of Appeals is composed of a panel of judges. The number of judges on each court varies depending on the district, but generally ranges from 3 to 13 judges per court. While the courts are geographically divided, the justices may also sit in panels of 3 judges to hear specific cases. In some instances, more judges may be assigned to a case to form a larger panel, depending on the complexity of the issues involved. Each Court of Appeals has a presiding judge who is responsible for managing the administrative and procedural functions of the court. The presiding judge is elected by the members of the court. The Court of Appeals judges are elected in partisan elections for 6-year terms. District courts. The district courts in Texas are the state's trial courts, and they have broad authority to hear a wide range of cases. They are among the most important courts in Texas as they handle major trials and disputes. District courts in Texas have general jurisdiction, meaning they can hear almost any type of case with a few exceptions. These courts can hear both civil and criminal cases of varying complexity, and they are often the first courts to hear major legal disputes before they may appeal to a higher court. District courts handle all felony cases, such as murders, robbery, drug trafficking, and other serious crimes. They also hear a wide variety of civil disputes, such as personal injury cases, property or contract disputes, probate cases, and family law. Texas has 459 district courts distributed across the state. The number of district courts in each county varies depending on the population size and the caseload. That is, larger counties may have multiple district courts, while smaller counties may have only one. In larger counties, district courts may be divided into specialized divisions based on the types of cases they handle, such as civil division, criminal division, family law division, or probate division. Smaller counties typically have a single district court that handles all types of cases. Each district court is presided over by a district judge, who is elected by the people of the district in partisan elections for a 4-year term. These judges have the authority to hear cases, make rulings on legal issues, issue orders, and in criminal cases, determine sentences, though juries may also make recommendations for sentences. Judges in district courts are generally expected to be impartial, fair, and knowledgeable in the law as they make decisions that have significant impacts on people's lives. County courts. Texas county courts are essential components of the state's judicial system, handling a wide variety of legal matters, and all 254 Texas counties has one. The county courts generally serve as the courts of limited jurisdiction, often dealing with less serious criminal offenses, civil cases, probate matters, and family law disputes. These courts are distinct from district courts, which have broader jurisdiction. County courts primarily handle Class A and Class B misdemeanors, civil cases involving amounts of money up to $200,000, probate cases, family law matters such as divorce, child custody, or protective orders, and juvenile cases in some counties. The county judge presides over the county court and is elected by the voters of the county and serves a 4-year term. The county judge is usually responsible for the administrative functions of the county as well, including overseeing local government operations. Justice of the Peace Courts. Texas Courts of Justices of the Peace, or the JP Courts, are among the lowest level courts in the state's judicial system, but they play a crucial role in handling certain types of legal matters. Texas has 817 Justice of the Peace Courts, which are found in each of the state's 254 counties. While the number of JP courts varies from county to county, they are generally distributed to serve local communities across the state. JP courts have limited jurisdiction, meaning they handle a narrow scope of cases compared to higher courts such as the county or the district courts. They deal primarily with low level criminal, civil, and traffic matters, as well as small claims disputes. In some cases, JP courts may also handle preliminary hearings in felony cases, such as determining if there's enough evidence to proceed with criminal charges to a higher court, usually a district court. However, JP courts do not try felony cases. Justices of the peace judges are elected to a 4-year term and while they do not have to be lawyers, they are required to have some legal training. Texas law specifies that a JP must be at least 18 years old, be a U.S. citizen and a Texas resident, be a resident of the precinct in which they are elected, and not have been convicted of a felony. Statutory courts. Statutory courts are established by the Texas legislature and generally handle more specialized cases, often related to particular regions. Statutory courts in Texas include municipal courts, probate courts, county courts at law, and specialty courts. Municipal courts. The legislature created municipal courts in every incorporated municipality in Texas. Municipal courts in Texas are local courts that handle minor offenses and violations of city ordinances within a specific city or municipality. They are considered the lowest level of court and they play a crucial role in maintaining local order and enforcing municipal laws. Municipal courts have jurisdiction over Class C misdemeanors, city ordinance violations, and in certain cities, municipal courts can handle civil cases and certain types of code enforcement cases. A municipal court is presided over by a municipal judge, who is typically appointed or elected by the city council. These judges may or may not have formal legal training depending on the city. Probate courts. Probate courts in Texas are specialized courts that handle matters related to the administration of estates, guardianships, and mental health commitments. The main purpose of probate courts is to ensure that the assets and affairs of deceased individuals are handled according to the law and to protect the interest of those who cannot manage their own affairs, like minors or incapacitated adults. Probate courts are typically presided over by a judge who has specialized knowledge in probate law. County courts of law. These courts were created by the Texas legislature to address a local need. They initially were created to handle the judicial functions of the county judge. The first statutory county court at law was created in 1907 in Dallas County. The legislature has continued to establish these courts on an ad hoc basis in response to a county's request and need. Counties with larger populations may have one or more of these courts. County courts of law have general, civil, criminal, or specialized jurisdiction and vary significantly from county to county. The county court's jurisdiction is defined by the particular statute that created the court. County courts at law typically handle cases involving misdemeanors, including those more serious than those handled by the constitutional county courts, and appeals from justices of the peace courts and municipal courts in some counties. The county court at law judge is an elected official, typically chosen through a partisan election for a 4-year term. The judge must be a licensed attorney practicing in Texas for at least 4 years. Specialty courts. Specialty courts in Texas are specialized courts designed to address specific types of cases that require unique handling due to their complexity or the needs of the individuals involved. These courts aim to offer more targeted interventions and support, often with a focus on rehabilitation, treatment, and diversion from the traditional justice system. Drug courts are designed to handle individuals who have been charged with crimes related to substance abuse. These courts offer a more rehabilitative approach rather than a purely punitive one. Veterans Treatment Courts focuses on providing treatment and support for veterans involved in the criminal justice system, especially those who have mental health issues, substance abuse problems, or trauma related to their military service. Mental health courts focus on individuals who have been charged with crimes but have mental health disorders. These courts aim to divert these individuals from the traditional criminal justice system and into treatment programs. Family violence courts handle cases involving domestic violence, focusing on both protecting victims and addressing the underlying issues that lead to violent behavior. DWI courts are designed for individuals who have been arrested for multiple offenses related to driving while intoxicated. These courts aim to reduce recidivism among individuals who struggle with alcohol or substance abuse. Juvenile specialty courts focus on rehabilitating young offenders and addressing the underlying issues that led to delinquent behavior rather than solely punishing them. Sex offender courts focus on individuals charged with sex related offenses and provide specialized treatment programs designed to reduce recidivism and ensure public safety. Civil and criminal law. In civil law, an aggrieved person or plaintiff files a complaint against the person accused of causing harm. The defendant will file an answer explaining why the allegations are not valid. The standard of proof the plaintiff must meet is the preponderance of evidence. That is, the plaintiff must show that the defendant is more likely than not the cause of the harm suffered by the plaintiff. The burden of proof is on the plaintiff, and civil cases are time consuming and expensive. To avoid this costly and time consuming process, arbitration and mediation were created. Arbitration is where the parties agree to present their case to a decision maker and to be bound by the decision. Mediation is where the parties try to reach a compromise resolution without going to trial. Mediation is especially popular because the parties are not forced into a particular decision, as they would be with arbitration. Both are methods of resolving disputes without the cost and risk of going to trial. In criminal cases, the state alleges a violation of criminal law and is represented by a prosecutor. Indigent criminal defendants are commonly represented by court appointed lawyers. In the case of a serious criminal offense, prior to the trial, there will be an indictment by a grand jury. The grand jury, consisting of 12 persons, determines whether there is sufficient evidence to justify a trial. If the jurors decide a trial is warranted, they will issue an indictment. An indictment is also known as a true bill. If a grand jury does not believe a trial is warranted, the jury issues a no bill decision. The suspect in a criminal case has the right to trial by jury, but they may waive that right and undergo a bench trial before the judge only. Felony juries have 12 members, misdemeanor juries have 6. The verdict in a criminal trial must be unanimous. With criminal cases, the evidentiary threshold is beyond a reasonable doubt. If the defendant is found guilty, a separate hearing is held for sentencing, and the defendant may also appeal a verdict. An appeal may allege, for example, a trial error that affected the outcome occurred. Often, instead of a trial, a suspect will engage in a plea bargain, which is a negotiated agreement in a criminal case in which a defendant agrees to plead guilty in return for the state's agreement to reduce the severity of the criminal charge or prison sentence the defendant is facing. Judicial politics. William Clements, the first Republican governor to be elected in 1978 since Reconstruction, began appointing Republicans to the bench when there was a vacancy. By the early 1980s, competition began to appear in these judicial races, making them more expensive. With the increasing popularity of the Republican Party in Texas, along with having an incumbency advantage, Republican judges began to win re election. A perennial issue in Texas judicial elections is the cost of campaigns and the ethics of judicial candidates' solicitations for campaign funds. Voters do not give much money to judicial campaigns. Instead, it's lawyers, interest groups, and potential litigants that give money. Often, trial lawyers back Democratic judges, who are more likely to lean liberal or pro plaintiff. Civil defense lawyers may back Republican judges, who are more likely to be conservative or pro defendant. One difference between the campaigns of civil court judges and the campaigns of criminal court judges is the amount of money involved. A candidate for the Texas Supreme Court may raise around $1 million for a campaign, whereas a candidate for the Texas Court of Criminal Appeals may raise only around $100,000. The difference has much to do with the relatively low incomes of criminal defense lawyers and prosecutors. Thus, races for the Texas Supreme Court, which deals with civil cases rather than criminal cases, garners more attention from those with money to contribute. These contributions and contributors for judicial races raise concern about the neutrality of judges in Texas. A poll of judges showed that 86% believed that campaign contributions had some influence on judicial decisions. In the same poll, 83% of the public thought judges were strongly or somewhat influenced by contributions in their decisions, and 99% of lawyers believed campaign contributions had at least some influence. Not all judges get their initial judicial seat through elections. A large percentage of judges initially get on the bench through appointment by the governor to fill a vacancy between elections. Currently, about 55% of appellate judges and 37% of trial judges initially gained the bench through appointment. Of course, partisanship, as well as the advantage of incumbency, also plays a role when judges who gain the bench by appointment campaign to retain their seats. Texas is not the only state that elects as judges. 38 other states elect at least some of their judges, either through partisan or nonpartisan elections. The rest of the states appoint judges through a variety of methods, such as merit selection, legislative appointment, or governor appointment. Judicial reform. In Texas, there have been ongoing discussions and proposals for judicial reforms aimed at improving the efficiency, transparency, fairness, and independence of the state's judicial system. Some of the key judicial reforms that have been considered or proposed in Texas include the following. Critics argue that partisan elections undermines judicial independence and leads to the perception that judges are politically biased. Some reform advocates have called for transitioning to nonpartisan elections for judges. This would mean judges would run without a party label on the ballot, potentially reducing partisan influence and allowing voters to focus more on qualifications and merit rather than political affiliation. Judicial elections in Texas can be expensive, with the candidates often raising large amounts of money to fund their campaigns. Critics argue that the reliance on campaign contributions can create conflicts of interest, as judges may feel indebted to large donors or special interest groups. There have been proposals to limit campaign contributions for judicial candidates, impose stricter disclosure requirements for campaign donations, and introduce public financing of judicial campaigns to level the playing field. Judges in Texas are elected to serve for long terms, that is, 6 year terms for appellate courts and 4 year terms for district courts, and there are no term limits. As a result, some judges can serve for decades, leading to concerns about a lack of turnover and accountability. There have been calls for imposing term limits on judges, particularly for appellate courts. Term limits could potentially bring fresh perspectives to the bench and encourage judicial accountability. Term limits could prevent judges from becoming entrenched in power and encourage new, diverse perspectives. However, opponents argue that term limits could remove experienced judges and disrupt the continuity of the judicial system. Merit based judicial selection. Voters are often uninformed about qualifications of judicial candidates and thus rely on party labels to determine who to vote for. Also, the high number of candidates on the ballot makes it difficult to become an informed voter. Many reformers have proposed to move towards a merit based selection system for not only the Texas Supreme Court, but other appellate courts as well. This system would make the selection process more focused on qualifications and less on political affiliation. Merit selection would involve a commission that vets potential judges based on their character and temperament. A list of approved judicial nominees is then presented to the governor, who appoints one as a judge. After a period of time, that judge runs in a retention election. The judge does not face an opponent, but the ballot question asks voters whether the judge should be retained in office, basically yes or no. A more independent selection process for the Texas Supreme Court could improve the public's confidence in the court's impartiality and fairness, especially in high profile and controversial cases. The merit based system is seen as a way to select judges based on qualifications and experience rather than a political affiliation or the ability to raise campaign funds. It could help reduce the influence of special interest and money in judicial elections. However, the merit system itself cannot be insulated from politics. For instance, how would the initial merit selection committee members be chosen? Most appointments for the Texas executive branch are made by the governor with the approval of the Senate. Both the governor, by their initial nomination, and the Senate's either approval or rejection of the commissioners will reflect partisan reasoning. Improving judicial accountability. Judges in Texas are generally subject to oversight by the State Commission on Judicial Conduct, which investigates complaints about judicial misconduct. However, some critics argue that the current system lacks transparency and accountability. Some reforms have called for greater transparency in the investigative process of judicial misconduct cases and for the creation of a clearer standards for judicial behavior. There have also been proposals to create a citizen review board or other independent bodies to review complaints against judges. Increasing accountability and transparency could help restore public trust in the judiciary and ensure that judges are held to high ethical standards. The end.